HOA Karen called me a squatter on my own property. Didn't know I owned the title to her house too. Imagine spending millions on a gated estate where everything from the paint color to the grass height is dictated by an autocratic homeowners association, HOA. You're enjoying your first breakfast in your new neighborhood when a woman in expensive athleisure wear, with a severe blonde bob and oversized sunglasses, stomps into your garden, point a finger, and declares you a squatter. This isn't a simple misunderstanding. This is war. And in this war, she's a pawn. Me? I own the entire chessboard, including the legal title to the roof she's shouting under. The estates at Silverbrook wasn't just a neighborhood. It was a fortress built of manicured hedges, imported Italian marble, and unspoken rules. Located just outside Sarasota, Florida, this was where old money and newly minted tech fortunes converged to purchase the illusion of absolute, controlled tranquility. Every resident here had signed away a piece of their autonomy in exchange for perfect symmetry and guaranteed property values. The streets were swept daily. The exterior paint palette was restricted to a sterile range of whites and creams, and the official HOA manual governed the exact species of flora allowed to thrive, or rather, survive, on each plot. If there was a heaven for micromanagers, this was it. Alex, the protagonist, had just closed on the grandest estate in Silverbrook, house number 17. A visionary in decentralized tech, Alex had sold their latest startup for a figure with enough zeros to purchase the entire block, if desired. The house itself was breathtaking. A Mediterranean revival masterpiece featuring an infinity pool that melted into the horizon and meticulously maintained lawns. However, what Alex sought was not just luxury, but quiet. The constant, low-humming vigilance of the HOA was a calculated risk. On this particular bright, humid Florida morning, Alex was performing a small act of rebellion, one born not of spite, but of a desire for genuine peace. Instead of the monotonous, water-guzzling St. Augustine grass and approved boxwood hedges, Alex was transforming a corner of the enormous backyard near the mainland Nye into a small, native, xeriscaping meditation garden. They were using vibrant, drought-resistant coquina rock and planting local varieties like purple coneflower and liatris, plants that actually belonged in this environment. It was ecologically sound, beautiful, and utterly non-compliant with the HOA's rigid visual uniformity guidelines. Alex, dressed in comfortable linen, took a satisfied sip of coffee on the patio. The air was still, the only sound the gentle burbling of a newly installed water feature. The sense of accomplishment was palpable. The work was personal, a grounding connection to the land after years spent in the abstract world of coding and high finance. The piece lasted exactly 12 minutes and 45 seconds. The sound that shattered the moment was sharp and irritating. The thwack, thwack, thwack of high-end athletic sneakers on the paved walkway, approaching with unnecessary urgency. A shadow fell over the coquina rocks. Standing at the edge of the patio, arms crossed tight over a neon pink Lululemon top, was Brenda Farrow. Brenda was a woman in her late 50s, impeccably maintained, with a gravity-defying blonde bob and enormous, mirrored aviator sunglasses that concealed the intent behind her stare. She radiated an aura of expensive board authority. Her very posture conveyed that she was perpetually disappointed in the world around her, and she was here to correct it. Brenda didn't introduce herself. She didn't offer a polite greeting. She simply pointed a long, manicured finger at Alex, then at the half-finished garden. Her voice was strained with immediate, absolute condemnation. The sound of a drill bit meeting porcelain. What is the meaning of this? You need to stop immediately. Alex looked up unfazed and offered a neutral smile. Good morning. I'm Alex. I just moved into number 17. This is my new meditation garden. Brenda did not return the greeting. Her lips curled into a tight, thin line of scorn. A garden? No, this is a code violation in progress. And who are you exactly? I've lived here for 11 years. I know every resident, every contractor, every landscaper. Your car is not registered in the community database. And those weeds, she gestured dismissively at the native flora, are non-compliant. The approved list is clearly outlined in the CC and RS, Section 4, Subsection B. You're operating outside the parameters. Alex stood up, calmly placing the coffee cup on a nearby table. I assure you, I am operating well within my legal parameters, MS. Farrow, Brenda Farrow, and I am the chairwoman of the Architectural Review Committee, which means I'm the parameters as far as external aesthetic compliance goes. and I'm afraid your name doesn't ring a bell. You see, Mr./Ms. Alex, Silverbrook has a very strict policy regarding property ownership registration. I contacted Carol, the property manager, this morning after seeing the unusual delivery trucks yesterday. Your name is not listed as the registered deed holder for this property. That deed belongs to a corporate entity, an LLC, I believe. Brenda leaned forward conspiratorially, her voice dropping, though still carrying the force of public accusation. We are highly suspicious of individuals attempting short-term rentals, or worse, squatting, in our homes to avoid the rigorous background checks and fee structures. I am giving you a courtesy warning. You have 24 hours to provide authenticated proof of ownership, or I will have HOA security serve you with an immediate vacate notice. And trust me, you do not want to cross me on a compliance issue. I am the one who ensures our property values remain untouchable. The use of the word squatter was not just a violation of decorum. It was a calculated act of high-class aggression. It stripped Alex of dignity, turning a multi-million-dollar homeowner into a cheap interloper. Alex felt a distinct surge of something colder than anger, a thrilling, intellectual challenge. Alex met Brenda's glare, still smiling, but the smile no longer held warmth. It was analytical, almost predatory. Miss Farrow, I appreciate your dedication to vigilance. As a true legal owner of this property, I can assure you there is no squatting involved. However, your immediate leap to eviction notices and public accusations of illegal residency based on a cursory glance at a corporate title is troubling. It suggests an overzealous, perhaps even defamatory, application of your committee power. Alex paused, letting the word defamatory hang in the air. I suggest you take those 24 hours to consult the full scope of the HOA's legal documents, particularly the liability clauses concerning false accusations against a resident. You may find that your position as chairwoman, while important, does not grant you immunity from the very rules you claim to enforce. I would hate for a misunderstanding about a few native plants to lead to serious legal consequences for you personally. Brenda scoffed, a theatrical roll of her eyes visible even behind the mirrored lenses. Legal consequences? From a suspected tenant? Good luck with that. I'm taking photos now. Expect a violation letter by 5 p.m. And those weeds better be gone by sunset tomorrow. She took several photos of Alex's garden with her expensive phone, the flashbulb popping unnecessarily, before turning sharply and marching back down the path, her sneakers echoing the sound of a retreating, yet confident judge. Alex watched her go, then retrieved the coffee. The sense of peace was utterly gone, replaced by a quiet, focused determination. Brenda Farrow had made a critical, catastrophic error. She had assumed that the corporate LLC holding the deed to house number 17 was a shield for a renter. What she didn't know was that the LLC, Ethelred Capital Group, was simply the tip of an iceberg. Alex was the sole owner of Ethelred, and Ethelred was structured as a multi-layered asset management firm. Alex walked back inside and opened a secure, encrypted laptop. It was time for a legal systems check. Okay, Brenda, Alex murmured, opening the HOA's digital covenants archive. You want to play by the rules? Let's play by all the rules. You call me a squatter. Let's see who is truly secure in their residency. Within minutes, Alex had confirmed the full extent of Ethelred Capital's assets in Silverbrook. The house number 17 deed was just the beginning. Ethelred had recently acquired the non-performing debt notes from the primary lender for the entire community. Furthermore, through a silent acquisition 6 months prior, Ethelred had gained a majority equity stake in Evergreen Management Solutions, the firm contracted by the HOA to handle all administrative and enforcement tasks. Alex wasn't just a homeowner. Alex was the economic overlord of Silverbrook, the shadow power behind the HOA's curtain. Brenda Farrow, the self-proclaimed architectural queen, was merely a salaried employee of the system that Alex now controlled, and she had just publicly threatened her boss, called him a criminal, and issued an illegal fine. Alex instructed a corporate legal team member via secure chat, initiate full review of Silverbrook HOACC and RS, prioritize section 3.7.b, community decorum, and pull all registration documents for house number 42, specifically noting the title holder's legal structure. It's time to teach the chairwoman what true, overwhelming compliance looks like. The adrenaline rush from Brenda Farrow's theatrics quickly subsided, replaced by the cool, calculating focus that had made Alex a titan in the tech world. Alex didn't see an angry neighbor. Alex saw a systemic vulnerability ripe for exploitation. Brenda had attacked with emotion and baseless authority. Alex would retaliate with dispassionate, irrefutable law. Alex settled into the expansive, ergonomically perfect home office, the morning light streaming over a desk capable of supporting half a dozen monitors. The only screen active was the one displaying the digitized repository of the estate's at Silverbrook Covenants, Conditions and Restrictions, CC and RS. This was not light reading. It was a constitution of a small, affluent tyranny, and Alex intended to treat it as such. The first goal was to confirm the full scope of power held by Ethelred Capital Group, Alex's main holding entity, through a series of carefully structured transactions months prior, designed to minimize tax liability and maintain extreme discretion. Ethelred had become the most dominant financial force within the Silverbrook community, yet remained completely invisible to its residents. Debt acquisition. Ethelred had quietly purchased a majority of the non-performing and underwater mortgage-backed securities, MBS, notes originated by the community's primary regional bank. This gave Alex, through the holding company, enormous leverage over the HOA's long-term financial stability and borrowing power. Management control. 6 months ago, Ethelred executed a majority equity acquisition of Evergreen Management Solutions, EMS, the third-party firm contracted to handle the HOA's day-to-day enforcement, finances, and administration. Brenda Farrow's direct contact, Carroll Property Manager, was an employee of EMS. This meant every violation letter, every architectural approval, and every maintenance contract passed through a company Alex effectively owned. Brenda Farrow just declared war on her own payroll provider. Alex mused, a slow, grim smile spreading across their face. The true power was already in place. Now it was time to find a precise legal mechanism to crush the opposition cleanly and permanently. Alex began a forensic analysis of the CC and RS, not looking for loopholes, but for rigid definitions, the structural rigidity that, when pushed too hard, would shatter, the weaponization of bureaucracy. Alex focused on 3 specific articles that could be leveraged against Brenda, the self-proclaimed architectural chairwoman. 1. The membership and ownership trap. Brenda's entire authority rested on her position as an esteemed, long-serving member of the board and chair of the powerful Architectural Review Committee, ARC. The CC and RS Article 5, Section C, stipulated that board members must be a registered physical owner of a unit within the community. Alex cross-referenced Brenda Farrow's title documents for house number 42, which were available through Ethelred's internal databases due to their debt acquisition leverage. As suspected, the title was held under the Farrow Family Revocable Trust, with Brenda and her husband, Robert Farrow, listed as co-trustees and beneficiaries. However, the legal definition of registered physical owner in the CC and RS was deliberately archaic and specific, designed to exclude purely corporate or trust ownership without additional certification. Brenda, in her zeal to protect the trust's assets from tax scrutiny, had inadvertently compromised her standing with the HOA. Technically, the trust was the owner, not Brenda Farrow, the physical person, and there was no supplementary affidavit on file confirming her individual physical owner status for HOA purposes. This was a classic legal technicality, ignored for years, but now a lethal weapon. The strategy: formally request the HOA Council, via Alex's control management company, to issue an immediate opinion on Brenda's compliance with Article 5, Section C. This challenges her right to hold office entirely. 2. The defamation clause, turning the tables. Brenda's primary offense was not the threat of fine, but the malicious public accusation. Alex located Article 3.7.b, Community Decorum and Conduct, a boilerplate clause designed to prevent neighbor disputes from spiraling into litigation. The clause prohibited any resident, guest, or owner from making false, unsubstantiated, or defamatory accusations regarding the legal standing, moral character, or compliance status of any other resident or owner. By calling Alex a squatter, Brenda had directly violated this clause. The consequence: mandatory fines, public reprimand, and potential suspension of HOA voting rights. The strategy: file an official formal HOA violation report against Brenda Farrow for violating Article 3.7b, demand a maximum fine allowable, initially $500, escalating daily, and a mandatory written apology. This forces the board, which Alex secretly controls through EMS, to rule against its own chairwoman. 3. The unilateral management right. This was a fail-safe. Article 10 of the EMS contract, which Alex's Ethelred Capital now held, contained a clause regarding management review and intervention. This clause allowed the property management firm, under extreme circumstances, like an imminent lawsuit or perceived fiduciary risk, to unilaterally suspend board or committee actions and call for an emergency organizational review to protect the community's financial interests. Brenda's threat to pass a new, potentially unconstitutional 48-hour eviction rule was a perfect trigger. Such a rule would violate established property rights and expose the HOA to massive liability. The strategy: if Brenda pushes her illegal eviction rule, Alex will have EMS issue a notice of fiduciary intervention, immediately suspending the entire architectural review committee and overriding the board's vote, citing the need to prevent catastrophic financial litigation. The action plan: overwhelm and execute. Alex formulated the plan into 3 distinct phases, prioritizing legal legitimacy over speed. This will be a clinical execution. Phase I, the paper barrage, immediate. Send 2 immediate, formal letters to Carol at EMS, who is now taking quiet instruction from Alex's corporate counsel. Letter A, the formal violation report against Brenda Farrow, house number 42, for breach of Article 3.7.b. Demand a formal hearing within 7 days. Letter B, the formal request for legal opinion regarding Brenda Farrow's eligibility to hold office under Article 5, Section C, Physical Owner Rule. Phase 2, the public confrontation, the meeting. Attend the inevitable board meeting, called to address the violations. Allow Brenda to argue her case and attempt to pass her illegal eviction rule. Before the vote, issue the bombshell, a document revealing Ethelred majority ownership of the debt notes and controlling stake in EMS. Trigger the notice of fiduciary intervention, immediately suspending Brenda's committee and forcing the board to vote on her personal fine. Phase 3, the legal foreclosure, the ultimate move. If Brenda refuses to pay the fines and continues the legal battle, the HOA, controlled by Alex, will place an immediate, escalating lien on house number 42. Ethelred Capital, as the largest lien holder and the primary mortgage note holder, will then have the legal standing to initiate the ultimate foreclosure action. The total duration of the plan was projected to be 60 to 90 days, culminating in a clean, legal seizure of the property should Brenda prove utterly unyielding. Alex leaned back, a sense of cold satisfaction settling in. This was far more interesting than debugging code. Brenda wanted to feel like the judge and the sheriff of this community. She was about to find out that Alex was the one who owned the courthouse, the bank, and the local police force. A single instruction was typed into secure communication portal for a corporate counsel. Begin Phase 1. Ensure every document is notarized and served with absolute adherence to protocol. This must be flawless. The next day began with a series of quiet, devastating legal maneuvers that contrasted sharply with Brenda Farrow's loud, public theatrics. Alex did not engage. Instead, the sophisticated machinery of Ethelred Capital Group was activated. Utilizing its controlling stake in Evergreen Management Solutions, EMS, the HOA's contracted management firm. By 9 a.m., 2 distinct, official-looking envelopes bearing the EMS logo and a certified legal notice stamped were dispatched by private courier. One was addressed to the HOA board of directors, and the other, personally, to Ms. Brenda Farrow, house number 42. The double strike, the first letter, delivered to Brenda, was a formal violation report. It was stark, bureaucratic, and devoid of emotion, a cold application of her own rules. Violator: Brenda Farrow, resident, house number 42. Article violated: CC and RS Article 3.7.b. Community decorum and conduct. Specific infraction: making false, unsubstantiated, and defamatory accusations against a registered property owner, house number 17, by publicly labeling the owner a squatter. Required action: a formal written retraction and apology to the aggrieved owner within 7 calendar days. Sanction: initial fine of $500, escalating to $1,000 per day starting on the 8th day until a written apology is received and the board of directors deems the violation cured. The letter was signed not by Carroll Property Manager, but by Mr. Philip Vance, Senior Counsel, Evergreen Management Solutions, a fictional position created by Alex's legal team to lend an air of unassailable corporate authority. The second letter, addressed to the full HOA board, was even more destabilizing. It was a formal request for a qualification review and legal opinion, challenging Brenda's fundamental right to govern. Subject: Eligibility Review of Board Member Brenda Farrow. Citing CC and RS Article 5, Section C. Requirement for board members to be registered physical owners. Stipulation. The letter meticulously detailed that house number 42 was legally titled to the Farrow Family Revocable Trust, not Brenda Farrow as an individual, thereby creating a material conflict with the registered physical owner definition. Request. Immediate suspension of Brenda Farrow from her board and committee duties, pending the receipt of an unambiguous legal opinion. To mitigate potential fiduciary risk to the association. Brenda received her envelope at 10:15 a.m. Her initial reaction was pure, incandescent rage. She stood in her immaculate kitchen, clutching the letter, the paper shaking in her hands. The audacity! She, the matriarch of Silverbrook, being fined and threatened with daily escalations by the very management company she thought she controlled. She immediately called Carol, the property manager, her usual target for verbal abuse. Carol, what in God's name is this Vance person doing? Fire him. This is a malicious personal attack orchestrated by that person at number 17. You tell them I am not paying this fine, and I will not apologize. I am calling an emergency board meeting and pushing to the 48-hour eviction rule this afternoon. Carol, instructed by Alex's unseen corporate counsel, maintained a facade of stress helplessness. Miss Farrow, I cannot fire Mr. Vance. He is senior corporate counsel and reports directly to the EMS CEO. And the request for the qualification review is already with the board. It is mandatory, according to Article 5. You must comply, or the fines will escalate. I advise you strongly to proceed to the formal HOA Appeals Committee. Brenda slammed the phone down, her face a mask of scarlet fury. She realized the battlefield had shifted. She could no longer simply issue an edict. She was now forced to engage with the system she thought was her puppet, the fatal countermove. Brenda's singular focus was on retaining her perceived power and crushing Alex. She saw the fines and the eligibility review as merely irritating distractions. Her priority was getting that emergency rule passed. She successfully leveraged her remaining influence with 2 loyal board members to call an emergency meeting for 5 p.m. that evening. The agenda, the immediate review and adoption of Emergency Rule 4.1.c. Brenda believed that by swiftly enacting this rule, the one that allowed the HOA to forcibly remove a suspected squatter within 48 hours pending investigation, she would render Alex's entire legal challenge moot. If Alex was forcibly removed from the property, the defamation complaint would be dismissed, and the eligibility review would become a stale matter of a non-resident. She was so focused on this tactical victory that she failed to comprehend the significance of the second letter regarding her own eligibility. She was inviting Alex to strike at her weakest point in the most public forum. Alex, meanwhile, received the minutes for the emergency meeting and smiled. Brenda was rushing headlong into the final trap. The attempted passage of Emergency Rule 4.1c was the final element required to activate Alex's Phase 2, the public confrontation. It was an overreach. It was demonstrably illegal under Florida property law. And it was exactly the imminent lawsuit and fiduciary risk that triggered the powerful management review and intervention clause in the EMS contract. Alex's final preparation before the meeting was simple. A single heavy document. The notice of fiduciary intervention was finalized, detailing Ethel Red Capital's control over the community's finances and management. This document, signed by the new actual EMS CEO, will be presented at the meeting. It was not a request. It was an order. Brenda believes she's about to cast a deciding vote. Alex mused at her corporate counsel. She's about to find out that the vote has been invalidated before she even walks into the room. The setting was ready. The opulent mahogany panel meeting room at the Silverbrook Country Club. Brenda would arrive expecting to be the judge. Alex would arrive ready to be the executioner. The meeting room at the Silverbrook Country Club, reserved exclusively for the board directors, was heavy with the scent of polished mahogany and stale ambition. It was 5 p.m. Brenda Farrow was seated at the head of the long table, flanked by her 2 loyal, if somewhat nervous, allies, Margaret, whose new fence design Brenda had arbitrarily approved, and George, who perpetually feared being fined for his pool cage. Brenda, dressed in a sharp, expensive blazer and accessorized with a string of pearls, projected an air of absolute control, despite the 2 devastating legal notices resting in her briefcase. She planned to dispose of the Alex problem first, before the administrative irritations could take root. Alex arrived precisely on time, accompanied by Mr. Henderson, the corporate counsel quietly representing Ethelred Capital Group and, by extension, Evergreen Management Solutions EMS. Alex wore simple, high-quality business attire. No flashy suits, nothing to suggest the staggering wealth or the power currently held. They sat across from Brenda, embodying calm competence against her brittle aggression. Brenda did not waste time. She banged a tiny, decorative gavel, a prop she cherished, and launched into a furious opening statement, deliberately ignoring Alex's presence until necessary. Ladies and gentlemen of the board, we have been forced into an emergency session by a malicious, baseless complaint filed against me, your dedicated chairwoman, she began, her voice ringing with self-pitying righteousness. But the real crisis is the rogue resident at house number 17. This individual, who has already violated the landscape code, is now attempting to weaponize our bylaws for personal revenge against my efforts to maintain our community standards. She continued, painting Alex as an existential threat to Silverbrook's property values. To protect our neighborhood and prevent any further instances of illegal occupation or residency disputes, I move that we immediately review and adopt Emergency Rule 4.1c. She read the rule aloud, emphasizing the key provision. Any resident who cannot produce a clear, verifiable chain of title or valid lease agreement within 24 hours of notification upon reasonable suspicion of squatting shall be required to vacate the premises within 48 hours pending a full board investigation. Margaret and George nodded vigorously. It was a power grab, naked and audacious, designed to circumvent due process and legally eject Alex before the board was forced to rule on Brenda's own defamation fine. Brenda then turned her attention to Alex, a sneer plastered on her face. Now, Mr./Ms. Alex, before we vote to eliminate your frivolous complaint and adopt this necessary protective measure, you may use your 3 allotted minutes to defend your actions. Alex did not stand up. They remained seated, meeting Brenda's gaze with unnerving steadiness. Thank you, Ms. Farrow. I am not here to defend my actions, which are entirely lawful. I am here to inform the board that your proposal, Emergency Rule 4.1c, is legally unsound and, if adopted, will be the single most expensive decision this board has ever made. Brenda cut Alex off sharply. That is baseless fear-mongering. We are within our rights to protect the community. Respectfully, Ms. Farrow, you are not, Alex countered smoothly. The proposed rule violates the Florida statutes regarding quiet enjoyment and due process for registered property owners. Passing it will expose the HOA to massive, guaranteed liability and immediate litigation from multiple angles, including my own. Your motive is clear: to use an illegal rule for personal retribution against a resident who dared to hold you accountable to the rules you claim to uphold. Alex paused, then delivered the first public revelation that chilled the room's temperature. And before this board commits financial suicide, there is a conflict of interest you must acknowledge. You received a formal notice today, Ms. Farrow, questioning your eligibility to hold this office because your title is held by a trust, not by you as a registered physical owner. Your decision to call this emergency meeting and attempt to ram through an illegal, retaliatory rule while under review for eligibility is a clear breach of your fiduciary duty to this community. Brenda slammed her hand on the table. I reject that. It's a technicality, a distraction. I move we vote immediately on Rule 4.1c. Margaret and George hesitated, sensing the danger, but Brenda shot them a glare that demanded loyalty. George meekly raised his hand. Margaret followed. The vote was 3-2 in favor of the rule, with Alex's 2 corporate council representatives voting no. Motion carried. Brenda declared triumphantly, her face flushed with victory. The rule is adopted. Now, Mr./Ms. Alex, expect your vacate notice tomorrow morning. You are adjourned. This was the moment Alex had been waiting for. The passage of the illegal rule was the final piece of evidence. Alex nodded to Mr. Henderson, who calmly reached into his briefcase and placed a thick, sealed document on the table, pushing it towards Brenda. With all due respect, Ms. Farrow, the meeting is not adjourned, Mr. Henderson stated, his voice slow and authoritative. And that rule is not adopted. I present the notice of fiduciary intervention and immediate management restructuring. Brenda looked at the document with contempt. What fresh nonsense is this? I don't recognize this firm. Alex took the floor again, the smile now completely gone. You will, Ms. Farrow. This notice is issued by the CEO of Evergreen Management Solutions. The company contracted to manage this HOA. It invokes Article 10 of the Management Agreement, which allows for unilateral intervention when the board takes action that poses an imminent, severe financial risk to the association. Passing an unconstitutional, retaliatory eviction rule against a property owner is the definition of severe financial risk. Alex continued, their voice gaining volume and undeniable weight. The intervention notice is simple, effective immediately. The board's vote on Rule 4.1c is nullified. Furthermore, due to the severe breach of fiduciary duty demonstrated by the reckless attempt to pass this rule, all committee powers, including the Architectural Review Committee, are hereby suspended pending a complete corporate audit. Brenda's jaw dropped. You can't do that. EMS reports to the board. You are lying. EMS reports to its corporate ownership. Ms. Farrow, Alex clarified, leaning in. And that ownership structure has recently changed. I'll make this very clear for you, and for the benefit of all directors here. I am the sole owner of Ethelred Capital Group, which holds a controlling equity interest in Evergreen Management Solutions. I am also the company that holds the majority of this community's outstanding debt notes. I do not just own house number 17. I am the effective economic owner of the Silverbrook HOA. The boardroom fell utterly silent. Margaret and George were rigid, staring wide-eyed at Brenda. She had led them, not into a victory, but into the mouth of a corporate leviathan. You call me a squatter, Alex finished, the tone low and final. You attempted to use your office to illegally remove me. And now, you no longer have an office to stand on. The new management is now taking control to ensure fiduciary responsibility. Your committee is suspended. The only item left on the agenda, which we will now vote on, is the fine for your violation of Article 3.7.b. You will pay the $500 fine and submit the required apology letter. George immediately changed his vote. Margaret followed suit. The motion to fine Brenda Farrow for defamation passed 4-1. Brenda Farrow, defeated, publicly humiliated, and stripped of every ounce of power she craved, rose slowly from the table. She didn't speak a word, simply gathering her belongings and storming out of the meeting room, leaving behind the shattered pieces of her self-made kingdom. Alex had won the war in a single, perfectly executed boardroom coup. Brenda Farrow's frantic exit from a country club meeting room left a vacuum, a lingering scent of expensive desperation. The remaining 3 board members, Margaret, George, and the one neutral director, David, were stunned into paralyzed silence, staring at the empty space where Brenda had been. The reality of Alex's revelation, that their new, quiet neighbor was the economic overlord of their carefully constructed community, was sinking in with chilling clarity. Alex, however, allowed no time for shock. The boardroom coup had been executed. Now came the immediate clinical cleanup and consolidation of power. Alex addressed the shell-shocked directors with calm authority. Gentlemen and madam, the past 10 minutes have demonstrated a profound lapse in fiduciary judgment driven by one individual's personal vendetta. To mitigate the severe legal and financial liability that Ms. Farrow's actions have created for the association, we must proceed immediately with the steps outlined in the notice of fiduciary intervention. Mr. Henderson, Alex's corporate counsel, stepped forward, his demeanor transitioning from silent observer to effective administrator. He began reading the official actions mandated by Evergreen Management Solutions, EMS, now fully controlled by Ethelred Capital Group. The sacking of Silverbrook's royalty. The actions were precise, irreversible, and designed to strip Brenda of any remaining symbolic or actual power within the hour. 1. Immediate suspension of the ARC. Effective immediately, Mr. Henderson announced. The Architectural Review Committee, ARC, is suspended. All pending approvals, including Ms. Farrow's most recent discretionary rulings, are frozen. The functions of the ARC will be absorbed directly by the Property Management Office, under direct oversight of EMS Senior Counsel, until a new, qualified committee can be established. This action is necessary to ensure fair and lawful enforcement of aesthetic guidelines, thereby preventing further resident lawsuits. This was the death knell for Brenda's reign. The ARC was her throne. It gave her the power to dictate the color of shingles, the height of fences, and the approval of garden designs. With the ARC suspended, her life's work, micromanaging the lives of her neighbors, was officially neutralized. 2. The final word on enforcement. Alex followed up the official statement with the practical reality. To the board, please understand. The $500 fine levied against Ms. Farrow for defamation, Article 3.7b, is now mandatory. Furthermore, the mandatory qualification review regarding her eligibility to serve on this board, Article 5, Section C, proceeds immediately. Her removal from all offices is expected within 72 hours based on a non-compliant titling of House Number 42 under the Farrow Family Trust. She is no longer a director. She is a resident in violation. 3. New management protocol. Mr. Henderson then circulated a new, binding memorandum. The board must ratify the permanent replacement of the previous administrative liaison with a new, dedicated governance team, reporting directly to Ethelred Capital's legal division. This team will focus on compliance and fiduciary transparency. Margaret and George, realizing they were one step away from being held accountable for rubber-stamping Brenda's reckless agenda for years, voted unanimously and instantly to ratify all new management protocols. They were desperate to prove their loyalty to the new power structure. The collapse of the facade. The fallout began instantly. Carol, the property manager, received the finalized documents from Mr. Henderson and immediately issued the official communications. First, an all-resident email went out, signed by the newly constituted board. Subject: Immediate Management and Committee Restructuring. Please be advised that, effective this evening, the Architectural Review Committee, ARC, has been suspended due to governance issues. All compliance matters will now be handled by the Property Management Office with direct legal oversight. This action ensures the financial stability and legal compliance of the Silverbrook Association. Second, a uniformed EMS security officer served Brenda Farrow at House Number 42 with 3 official notices. Notice of fine and escalation, defamation, the formal demand for the $500 fine, and the threat that the daily $1,000 escalation will begin exactly 7 days from the initial notice. Notice of suspension and removal. Official notification that she was immediately suspended from all HOA committees and board duties, pending final legal review of her eligibility. Notice of compliance audit. House Number 42, a completely new and unexpected notice. Given the board's documented concerns over her legal residency status and her documented history of making compliance-based threats, a full, comprehensive compliance audit of House Number 42 was scheduled for the following week, covering everything from noise regulations to the use of exterior lighting. Brenda, upon reading the notices, was utterly beside herself. She had been publicly humiliated in front of her peers, stripped of the power that defined her, and now faced a financial threat that was both perfectly legal and escalating daily. Her legal counsel confirmed the horror. Alex's move was airtight. The notice of fiduciary intervention was a contractual right derived from the debt holding and management control. The final, quiet threat. Alex concluded the board meeting with a clear mandate for the remaining directors. From this day forward, every decision will prioritize the legal, financial, and ethical integrity of the association. No personal agendas will be tolerated. The era of arbitrary rule enforcement is over. We will begin reviewing and relaxing many of the more onerous rules, but we will strictly enforce the rules that matter, especially those concerning financial obligation and community decorum. Alex had not just defeated a Karen. Alex had engineered a system reset. The satisfaction was complete. The power fantasy realized not through brute force, but through superior strategy, legal acumen, and financial weight. Alex had proven that in the world of high-stakes suburban drama, the one who owns the paperwork always wins. The new order had begun, and Brenda Farrow, now just a highly volatile resident facing an increasingly expensive fine, had become the first target of the newly cleaned-up, legally relentless HOA. Her attempt to call Alex a squatter had successfully activated the one true landlord she never knew existed. Brenda Farrow's initial shock quickly transmuted into predictable fury of a thwarted bully. Within 48 hours of the boardroom massacre, she retained a local litigation attorney, a slick, aggressive man named Barry Jenkins, and filed a massive lawsuit. The defendants were the Silverbrook HOA Board, Evergreen Management Solutions, EMS, and, by thinly veiled implication, Alex, the new resident at number 17. The lawsuit was a declaration of war, alleging unlawful board removal, abuse of fiduciary authority, and personal defamation stemming from the $500 fine and the forced suspension of the ARC. Brenda's goal was simple: reverse the board's decision, reinstate her power, and force Alex to pay massive punitive damages. This was exactly the reaction Alex and Mr. Henderson had anticipated and desired. She's done it, Alex told Mr. Henderson over secure line. She's taken a petty HOA dispute and forced it into the court system. Now, we don't just enforce the rules, we let the law define them. Mr. Henderson, acting on behalf of EMS and the HOA board, filed a response that ignored Brenda's emotional grievances and focused solely on one cold, legal fact: standing. The weaponization of the eligibility review. The core of the defense was a counterclaim. Brenda Farrow lacked the proper legal standing to sue the HOA over her removal from the board because she had never been legally qualified to hold office in the first place. In court, the argument was clinical. Mr. Henderson addressed the judge. "Your Honor, the plaintiff, Ms. Farrow, is suing the association over the removal of her committee chair position. Our defense rests entirely on Article 5, Section C of the CC and RS, which stipulates that any director must be a registered physical owner of a unit. The plaintiff's title, as presented in her own lawsuit filings, clearly states the property is owned by the Farrow Family Revocable Trust. The trust is the legal entity. Ms. Farrow is merely a co-beneficiary." Brenda's attorney, Mr. Jenkins, argued vehemently that this was an absurd technicality. The trust is controlled by Ms. Farrow and her husband. She is the resident. She pays the fees. She has lived there for a decade. The HOA has always accepted her as an owner for voting purposes. "That is precisely the point, Your Honor," Alex's counsel countered. "The board's previous administrative negligence in overlooking this discrepancy does not retroactively grant the plaintiff legal compliance. If the court allows Ms. Farrow to claim registered physical owner status simply because she resides there, it will create a material conflict with her own trust documents, which are designed specifically for tax and estate planning purposes." The gravity of the sank in for Brenda. If the court affirmed her as the individual physical owner for HOA purposes, her entire sophisticated multi-million-dollar tax shelter could be undermined, potentially leading to immediate tax and probate consequences. The definition that stripped her of power was also the one protecting her fortune. The judge, recognizing the delicate intersection of HOA bylaws, property law, and trust law, ultimately ruled in favor of the HOA's technical defense. Ruling, Brenda Farrow, due to the specific language of the Silverbrook CC and RS and the non-compliant titling via the trust, was not deemed a registered physical owner required to hold office. Her removal was, therefore, legally validated, transforming her entire lawsuit into a waste of the court's time and her own money. The ultimate flip. The ruling was a legal death sentence for Brenda's authority. She was no longer a board member, no longer a chairwoman, and no longer seen as an owner by the system she had so blindly revered. But Alex was not finished. The true power fantasy was about to unfold. Immediately following the court's ruling, Alex directed the EMS governance team to send a final, devastating notice to House Number 42. This notice was an administrative requirement, perfectly legal under the now validated HOA bylaws. It was a notice of compliance, residency and occupancy requirements. TO, the Farrow Family Revocable Trust, owner of House Number 42. From Evergreen Management Solutions, EMS. Subject, requirement to comply with Article 7.2, rules on rentals and resident approval. As the court has validated that the legal owner of Unit Number 42 is a non-individual trust entity, Unit Number 42 is now formally subject to the rental and occupancy restrictions outlined in Article 7.2 of the CC and RS. These rules apply to any property occupied by an individual who is not the registered physical owner. Article 7.2 was the ultimate tool of control that Brenda, ironically, had helped draft years ago to prevent less desirable residents from sneaking into the community via corporate leases. It was a suffocating layer of bureaucracy. Mandatory 60-day review. All non-owner occupants, including Brenda, must submit to a 60-day background check and administrative review. Application fee. A non-refundable $2,000 processing fee must be paid by the occupant. Lease requirements. The occupant must provide a valid, formally drawn lease agreement with the trust, the legal owner. To prove residency is authorized. Brenda Farrow, the proud resident of over 10 years, was now legally required to submit an application and a $2,000 fee to the HOA, run by Alex, for the privilege of continuing to live in her own multi-million-dollar house. She had to apply to be approved by the same committee she had just been thrown off of. She called me a squatter, Alex told Mr. Henderson, watching the news reports of the court ruling. Now, she is literally a non-owner occupant, facing potential eviction if her application is rejected or delayed. We have legally reduced the Queen of Silverbrook to a tenant at the mercy of the board. The delicious irony was palpable. Brenda was caught in her own legal net. She had fought to be recognized as an owner but was denied, validating a law that now treated her as a temporary, unapproved resident. Her battle for power had stripped her of her home security, and she was about to face the bureaucratic wrath of a management company that was now executing Alex's orders to the letter. She had become subject to the ultimate petty HOA torment. The court ruling confirming Brenda Farrow was not the registered physical owner of house number 42 was the key that unlocked the true administrative hell. Brenda, furious and wounded, refused to accept the defeat. She saw the new notice of compliance, residency and occupancy requirements, not as a genuine legal mandate, but as an extension of Alex's personal spite. She completed the residency and occupancy application with grudging contempt, attached the mandatory $2,000 non-refundable fee, a fee she had implemented years ago to deter undesirable short-term renters, and dropped the package off at the Evergreen Management Solutions EMS office, determined to rush the 60-day process. She was about to discover the terrifying difference between an overzealous amateur enforcing a rule and a cold, efficient corporate entity weaponizing bureaucracy, the bureaucratic torture. Alex had given the new, dedicated governance team at EMS, overseen by Mr. Henderson, a single, unwavering directive: absolute, immediate, and microscopic adherence to all procedural requirements for house number 42. No expediting. No exceptions. The objective wasn't swift eviction yet. It was attrition, the calculated process of using paperwork to drain Brenda's resources, time, and sanity. The 60-day review clock began ticking, only to be reset repeatedly by the smallest administrative flaw. Week 1. The missing signature. 10 days after submitting her application, Brenda received an official, certified letter from EMS. Subject: Deficiency Notice, Occupancy Application Unit Number 42. Dear Ms. Farrow, your application is deemed deficient. Per Article 7.2 to be point 4, the attached Declaration of Occupancy form requires the signature of the primary trustee of the Farrow Family Revocable Trust. Your husband, Mr. Robert Farrow, signed as a co-trustee. Please resubmit the form with the correct signature. The 60-day processing clock is hereby reset to day 1 upon receipt of the corrected documentation. Brenda had to hunt down her perpetually traveling husband, forcing him to FedEx the correctly signed document, wasting 4 days. The clock restarted. Week 3. The expired ID. 15 days into the second 60-day cycle, another certified letter arrived. Subject: Deficiency Notice, Occupancy Application Unit Number 42. Dear Ms. Farrow, the copy of your driver's license submitted appears to have expired 4 weeks prior to the date of submission. Per our standard operating procedure, we require a current valid government-issued photo ID. Please resubmit. The 60-day processing clock is hereby reset to day 1 upon receipt of the corrected documentation. Brenda had indeed let her license expire during her preoccupation with the lawsuit. The Department of Motor Vehicles' wait times in Florida were legendary. She spent a harrowing, infuriating day obtaining the new license, restarting the clock for the 3rd time. Week 6. The unacceptable lease. After nearly 2 months, the clock finally reached day 30. Then, the most complex demand yet. Subject: Final Deficiency Notice, Occupancy Application Unit Number 42. Dear Ms. Farrow, your submitted residential agreement between you and the Farrow Family Revocable Trust is insufficient. Per our legal review, it must be drafted as a formal, legally enforceable lease agreement for a minimum of 12 months, detailing rent consideration, and all standard provisions: maintenance, insurance, arbitration. The agreement must be certified by an independent, non-trust-related attorney. Please resubmit the corrected, certified document. Brenda realized the trap. They were requiring her to treat her own house as a rental property, complete with a binding, formal lease and independent legal fees, all to satisfy a rule she herself had helped create. She was drowning in her own red tape, the weaponization of fines. While Brenda was engaged in the endless application cycle, Alex launched a second front, the compliance audit of house number 42. Under Alex's new regime, the HOA had promised fairness but also strict, relentless enforcement of remaining essential rules. House number 42 was the first to face this new standard. Alex hired a specialized inspection firm, whose task was to find every minute violation of the 400-plus page CC&RS. The goal was not to fix issues, but to generate escalating daily fines that would crush Brenda's liquidity and create a massive, undeniable lien against her property. The results came back swiftly, based on years of accumulated, minor neglect that Brenda had previously overlooked because she was the enforcer. In just 1 month, Brenda received over $25,000 in escalating and flat fines. She desperately called Carol, demanding to speak to the board's new president, Alex. Carol remained polite but firm, citing the new anti-personal intervention policy. Ms. Farrow, per the new board mandate, all communication regarding violations must adhere to Article 12.3. Formal appeals procedure, Carol explained. This requires submitting a written brief detailing the error, along with a non-refundable $500 administrative review fee per violation. You have approximately 15 violations, Ms. Farrow. That would be $7,500 just to begin the appeals process. Brenda was trapped. She could not pay the fines without hemorrhaging her savings, but every day she delayed, the escalating fines ate further into her home equity, creating a larger lien for the HOA, controlled by Alex, and jeopardizing her mortgage. She had spent a decade building a system of punitive, inescapable bureaucracy, and now that system had turned on its creator with a cold, corporate ferocity that no amount of screaming or entitlement could defeat. She had called Alex a squatter to leverage her power. Now, Alex was leveraging the very letter of the law to legally bankrupt her and seize her home, all without raising their voice or touching a single blade of grass on her property. The legal system was delivering the ultimate, non-violent vengeance. 2 grueling months had passed since Brenda Farrow had been trapped in the bureaucratic labyrinth of her own making. Her frantic attempts to navigate the never-ending occupancy application cycle were futile, the 60-day clock constantly resetting due to minute, legally mandated deficiencies. Simultaneously, the escalating daily fines for the minor aesthetic violations had ballooned her debt to the HOA, controlled by Alex, to a staggering $45,000. Brenda's cash reserves were decimated by legal fees, administrative charges, and the sheer impossibility of addressing every escalating fine while fighting to renew an expired driver's license just to satisfy a new document request. The stress had taken its toll. The Queen of Silverbrook was now a shadow of her former self, rarely leaving house number 42, now a fortress under silent legal siege. The fiduciary crisis, the most critical consequence of the mounting HOA debt, was a disruption to Brenda's primary financial obligation, her mortgage. Under Florida law and the Silverbrook CC&RS, unpaid HOA liens are considered super priority liens, meaning they take precedence over almost all other claims, including the original bank mortgage. Brenda's primary lender, First Federal Bank, received the required notice from the HOA, Evergreen Management Solutions, directed by Alex, detailing the enormous delinquent lien. The bank, seeing their primary collateral, the house, being rapidly devalued by a massive, legally enforceable debt, panicked. They sent Brenda a notice of default and acceleration, demanding she pay the $45,000 HOA lien immediately or risk having her entire mortgage balance called due. Brenda, completely out of liquidity and legal options, watched her world crumble. She was financially ruined, but she still believed she owned her house. This was the moment Alex had been waiting for. The initial fight was about power. The final move was about ownership, the ultimate acquisition. While Brenda was distracted by the escalating fines and the bureaucratic torment, Alex's corporate vehicle, Ethelred Capital Group, had been executing the final, devastating piece of the strategy with surgical precision. Ethelred had quietly approached First Federal Bank, using the leverage gained from holding the majority of the community's debt notes and highlighting the instability caused by Brenda's litigation. Ethelred presented an irresistible offer. Purchase Brenda's distressed mortgage note at a deep discount. The bank, eager to offload a suddenly toxic, highly litigious asset, accepted. Alex did not purchase the house. Alex purchased the debt. The ownership of the mortgage note for house number 42 was swiftly and discreetly transferred to a new, clean shell entity under Alex's control, Silverbrook Acquisitions, LLC. No public filing was made regarding the beneficial owner. The only change was the name on the payment coupon. The knock on the door. On a Tuesday afternoon, a professional, uniformed process server approached house number 42. Brenda, fearing another fine notice, refused to open the door, but the law required acceptance. The server legally affixed a large, certified envelope to her ornate front gate. The documents inside were final and absolute. Document 1, Notice of Mortgage Assignment and Acceleration. This letter informed Brenda that her mortgage had been transferred from First Federal Bank to Silverbrook Acquisitions, LLC. Furthermore, citing the unresolved HOA default and lien $45,000 as a material breach of the mortgage contract's covenants, Silverbrook Acquisitions was formally accelerating the loan. This meant the entire remaining principal balance of the mortgage, several $1,000,000, was immediately due. Failure to pay within 30 days would result in foreclosure. Document 2, Notice of HOA Lien Foreclosure. This notice, from the Silverbrook HOA Board, effectively Alex, informed Brenda that due to persistent willful failure to pay the $45,000 in legally levied fines and fees, the association was initiating a judicial foreclosure action to seize the property and recoup its losses. This separate, concurrent action meant the HOA was using its priority lien status to sell the property at auction. Brenda's personal attorney, Barry Jenkins, was the first to see the full scope of the disaster. He called Brenda immediately, his aggressive swagger completely gone. "Brenda, listen to me. This is bad. The foreclosure from the HOA is legally sound because of the fines. But the acceleration from the mortgage holder is a killer. I checked the assignment records. Silverbrook Acquisitions, LLC is the new lender. Who are they? Some hedge fund?" Brenda stammered, her voice shaking. "No, Brenda. I did a deep corporate search. Silverbrook Acquisitions, LLC is a subsidiary of a parent company that shares significant legal and ownership structure with Ethelred Capital Group and Evergreen Management Solutions." Jenkins paused, then delivered the final, crushing blow, the one that validated Alex's opening declaration of power. The person you called a squatter, the resident at number 17, Alex, she owns your house's debt. She is your lender. She controls the HOA that fined you. She has legally manufactured a situation where both the lender and the lien holder are suing you simultaneously to take the title. The full power fantasy realized. The realization was a moment of profound, painful clarity for Brenda. She hadn't been fighting a disgruntled neighbor. She had been fighting a meticulously planned corporate takeover. Her arrogant, baseless accusation, "You're a squatter on my property," had been turned into a grim prophecy. Alex had become the judge, controlling the HOA's legal process, the sheriff, initiating the lien foreclosure, and the bank, accelerating the mortgage. Brenda had weaponized petty rules. Alex had weaponized the entire legal and financial infrastructure of the community. The satisfaction for Alex was complete. This was not revenge born of malice, but perfect surgical execution. Brenda Farrell's empire, built on the shifting sand of perceived authority, had collapsed under the weight of genuine, concentrated financial power. The only remaining steps were the final, formal surrender. Brenda, cornered and facing the loss of her home, her reputation, and her entire fortune, instructed her attorney to call Alex. The time for fighting was over. The time for begging had begun. The issuance of the simultaneous foreclosure notices, one from the HOA lien, controlled by Alex, and one from a mortgage holder, Silverbrook Acquisitions, LLC, also controlled by Alex, sent a seismic shockwave through the estates at Silverbrook. It wasn't just a legal matter. It was a public spectacle. In a community obsessed with appearances, the sight of a certified legal notice affixed to the gate of house number 42 became the main topic of conversation at the country club and the tennis courts. Brenda Farrow, once the undisputed monarch of compliance, was now a pariah. The subtle, quiet satisfaction of the other residents was palpable. Years of petty tyranny, arbitrary fines, and the constant fear of being targeted by the Architectural Review Committee culminated in this moment of collective, legally sanctioned schadenfreude. Brenda, realizing the game was over, became a recluse. She stopped answering calls. The windows of house number 42 remained perpetually draped, and her expensive SUV stayed parked in the garage, accumulating minor dust, a violation she could no longer be bothered to worry about. The retreat. Brenda's attorney, Barry Jenkins, delivered the grim news. There was no defense left. The HOA fines were valid and overwhelming, and the mortgage acceleration was legally executed by the new lender. Fighting meant spending millions in litigation only to delay the inevitable foreclosure, resulting in total financial ruin. The only viable path was surrender. Jenkins contacted Mr. Henderson, Alex's corporate counsel, requesting a final confidential settlement meeting to discuss terms for an orderly exit. The meeting was scheduled not in the opulent country club, but in Mr. Henderson's stark, glass-walled office in downtown Sarasota, a neutral corporate environment that emphasized the cold, transactional nature of the final negotiation. Brenda Farrow walked into the room a defeated woman. The severe bob was slightly undone. The expensive clothing looked wilted and the bright, aggressive makeup was absent, revealing the stress beneath. She avoided Alex's gaze, focusing instead on the polished surface of the conference table. Alex was present, flanked by Mr. Henderson, maintaining the same composed, measured presence they had exhibited since the initial confrontation. Brenda's attorney, Jenkins, spoke first, his voice drained of its usual courtroom bravado. "We acknowledge the legal validity of the foreclosure actions. Ms. Farrow is willing to execute a deed in lieu of foreclosure for both the HOA lien and the mortgage. We seek only to negotiate a clean break, without further punitive action or pursuit of a deficiency judgment." Alex leaned forward slightly, their eyes finally meeting Brenda's. The tone was not triumphant, but utterly decisive. "Ms. Farrow, you initiated this. You used the arbitrary power granted by this community to attempt to criminally label and forcibly evict a lawful property owner. You made this personal, and you escalated it to the point of severe financial liability for the association, which I now represent. The time for negotiating your escape is over. The time for accountability has arrived. The terms of surrender." Alex placed a single document, the settlement and release agreement, on the table. It was a final decree, perfectly structured to fulfill Alex's goals of legal justice, public retribution, and financial finality. The agreement was non-negotiable and contained 3 clauses that defined Brenda's collapse. 1. The financial cleanse, deed in lieu. Brenda Farrow, Robert Farrow, and the Farrow Family Revocable Trust will immediately execute a deed in lieu of foreclosure, transferring all interests in house number 42 to Silverbrook Acquisitions, LLC, Alex stated. In exchange, the HOA EMS will forgive all outstanding fines, fees, and liens, totaling over $45,000. Silverbrook Acquisitions will forgive the entire mortgage balance, including the accelerated principal. You walk away with nothing, but you walk away debt-free. We will not pursue a deficiency judgment. This was a calculated act of mercy born from strategic necessity. Alex didn't want messy bankruptcy proceedings. They wanted clean title and quick possession. Brenda would be financially solvent, but stripped of her primary asset and her status symbol. 2. The public humiliation, the apology. Clause 2, Mr. Henderson continued, his voice monotone, requires Miss Farrow to compose and deliver a formal, signed letter to the entire Silverbrook community. This letter must explicitly state that she made false, baseless, and defamatory accusations of illegal occupancy against the owner of house number 17, and that she abused her position and authority for personal gain. This letter will be mailed to every registered resident within 48 hours of this agreement being signed. Brenda visibly winced, her last thread of pride snapping. This was the true price. She had to publicly admit her wrongdoing to the community she had sought to dominate. 3. The silence of the defeated. Finally, Clause 3 is a standard but comprehensive, non-disparagement and confidentiality agreement. Alex concluded. Ms. Farrow agrees never to discuss the specifics of her removal, the financial terms of the settlement, or the identity of the beneficial owner of Ethelred Capital Group. Any violation will result in the immediate and successful pursuit of all previously forgiven debts and a massive breach of contract suit. Brenda knew she had been comprehensively beaten. She had called Alex a criminal. Alex responded by legally seizing her home and forcing her to apologize to her former victim. Tears welled up in her eyes, not repentance, but of sheer, bitter defeat. Her attorney leaned close, whispering, "Brenda, sign it. It's the best deal you'll ever get. You keep your retirement fund." With a trembling hand, Brenda Farrow signed the document, officially surrendering her position, her power, and her property to the person she had so arrogantly declared a squatter. The pen stroke marked the end of her reign, and the complete fulfillment of Alex's legal power fantasy. Alex watched her sign, not with joy, but with the quiet satisfaction of a complex problem solved perfectly. Justice, measured not in violence, but in the meticulous application of the law, had been served. The crisp, signed settlement and release agreement was the final period on the brutal chapter of Brenda Farrow's reign. Within 3 days, she was gone. The movers worked quietly, officially emptying house number 42, now the legal property of Silverbrook Acquisitions, LLC, Alex's entity. Her departure was marked by one last, crushing act of public self-abasement. The mandated apology letter, delivered to every mailbox in the community. The letter was a masterpiece of legal compliance and public shame. It briefly detailed her resignation and removal from all offices, admitted to making false, unfounded, and defamatory accusations of illegal occupancy against the owner of Unit Number 17, Alex, and apologized for the abuse of power that caused legal instability to the association. The residents, who had endured Brenda's tyranny for years, read it with profound, quiet satisfaction. The tyrant had not merely been deposed. She had been forced to confess her sins in writing. The Great Reform. With the immediate threat neutralized and the primary agitator exiled, Alex, now officially the HOA Board President, elected unanimously by the intimidated and reformed remaining directors, initiated the final phase, the system overhaul. The goal was not to establish a new dictatorship, but to create a fairer, leaner, and legally sound governance model that respected property rights while maintaining legitimate standards. 1. Fiduciary and ethical cleanse. Alex first focused on transparency. An independent auditor, appointed by Ethel Red Capital, released a public report detailing Brenda's gross misuse of HOA funds, confirming that she had used the arbitrary fines and fees to maintain large, unnecessary slush funds and approve expensive, non-essential contract for friends. This report further validated the fiduciary intervention and cemented Alex's authority as the community's necessary savior. 2. The rules revolution. Alex spearheaded a complete surgical review of the CC and RS. The goal was to eliminate all subjective, arbitrary, and legally vulnerable rules that Brenda had weaponized. Abolished. The draconian fines of minor infractions like unapproved door colors and excessive mailbox decorations were removed. Relaxed. The landscape rules were significantly liberalized, specifically to encourage native, sustainable Florida xeriscaping, exactly the type of garden that had started the initial confrontation. Alex's own meditative garden became the model for the community standard. Strengthened. Rules concerning financial obligations, noise disturbances, and true health/safety hazards were made clearer and strictly enforceable, but with a fair, multi-step appeals process that didn't require exorbitant non-refundable fees. Silverbrook began to breathe. The oppressive atmosphere of fear lifted, replaced by a genuine sense of self-determination. Residents could choose slightly different shades of exterior paint, plant small flower beds, and park their delivery vehicles without fearing a $1,000 fine. Alex had not destroyed the HOA. They had redeemed it, the lesson of true power. Alex stood on the patio of house number 17, gazing at the lush, thriving native garden. The coquina rocks were perfectly situated. The purple coneflowers were blooming, and the air was still and peaceful. The satisfaction of winning was profound, but it wasn't the petty joy Brenda had sought. It was a deep, intellectual gratification of demonstrating a crucial truth. Power is not found in noise or titles, but in ownership and the mastery of the structure. Brenda Farrow believed power resided in the gavel and the chairwoman title. She was a frontline enforcer, confusing her position with true authority. She was a pawn who thought she was a queen. Alex understood that true power resided in the deed, the debt note, and the controlling corporate equity. Alex owned the system that made the gavel and the title relevant. The ultimate power fantasy was not the moment of triumph in the boardroom, but the quiet, subsequent ability to redefine the community's constitution and create a better, fairer system from the top down. Alex realized that the entire confrontation was a metaphor for control in the modern age. Brenda tried to exert personal control through bureaucratic intimidation. Alex exerted systemic control through financial leverage and legal precision. The irony remained the sharpest tool. Brenda had branded Alex as a criminal squatter in an effort to secure her petty domain. But in the end, Alex had legally stripped Brenda of her status, her dignity, and her home, demonstrating conclusively that the person holding the title, not the person shouting the rules, always holds the ultimate card. House number 42 was swiftly renovated and later sold to a quiet, young family who appreciated the revised, relaxed standards. Alex, having achieved the ultimate goal of stability, quiet, and reform, settled into life in the estates at Silverbrook, the silent, benevolent force ensuring that no Karen would ever again hold the community hostage. The neighborhood was secure, governed by law, not by malice. The story was complete. The squatter had won, because the squatter was a landlord all along.